Hello, this is David Mandell, one of the principals and founders of OJM Group. I'm pleased to provide this month's OJM webinar, and that's going to be on the topic of asset protection, and specifically how to avoid the 3 asset protection mistakes made by most clients. Now, before we get into the topic of the webinar, let's talk about materials. And if you're new to OJM webinars, then you'll see a lot of books here you probably haven't been exposed to before. If you're a veteran of these webinars and potentially a client of ours, then you've probably seen them. We've got books for physicians, our flagship book on the left for doctors only, books for physicians in particular states, written with attorneys in those states. We've got a CME piece, risk management for the practicing physician, which is a Category 1 CME monograph where you can get CME credits for free online. By every 2 chapters you get 1 hour, total of 10 chapters in 5 hours. We've got a couple of books specifically that we co-wrote with clients who are books basically interviewing them and solutions for particular kinds of physicians, one with orthopedic surgeons with Dr. Peter Millett, and one for dermatologists with Dr. David Goldberg. We've also got books for non-physicians, including Fortune Building for business owners and entrepreneurs, which we've had out for a number of years, and Wealth Management Made Simple. And that is our new book on investing. It's about 150 pages, all new material. Very proud of it, and it's taken about a year to put together, and it's just coming out now. It'll be coming out this month in Kindle, in iPad, and hard copy. And so for anybody, even a veteran, even someone who's been a long-time client of ours, this is a new book, and we're excited to get that out. So at the end of this webinar, I'll tell you how to get those books. So asset protection. Certainly on our consulting side of our wealth management firm at OJM, we are able to provide an analysis of clients from both a business point of view and a personal point of view in terms of asset protection. What assets does the business or do you have personally? What is their current level of exposure? And what are your options, pros and cons, costs and benefits to protect those assets, whether it's your home or your investments or your business's accounts receivable or its intellectual property or your qualified plan, your IRA. We can analyze all of those. I still maintain my law practice. I am a member of the bar in California and New York and take on small handful of clients every year, and it's just in the areas of asset protection and putting in place some of these tools. Prior to OJM, going back 10, 15, 20 years ago, I practiced law in California and New York relatively full-time. And so really for 22 years, I've helped clients in this field. And I've seen these 3 common mistakes we'll talk about pretty often. And it's fairly common that clients are making these mistakes. Now, why would you want to protect assets in the first place? Why is asset protection even important? Well, for the physicians on the line, certainly they're probably concerned about malpractice because it's something they face every day in dealing with patients. And malpractice jury trial court awards can be in the millions of dollars, sometimes even more than the malpractice insurance in place. But certainly we have attorneys as clients. They have professional liability. We have all sorts of businesses from manufacturing to service to real estate, et cetera. And they have different types of liability, either from customers or competitors or to the government or to the third parties from things like product liability or slip and falls, et cetera. Anyone who's employing employees has potential liability there. And certainly there's a lot of great speakers and attorneys who speak on how to limit that liability in terms of your the way you operate your business. Personal liability from a point of view of personal guarantees, probably where more clients I've seen get in trouble is on that, where they take out a bunch of loans, they are either expanding their business or real estate, and then turns out that there's a downturn or recession, and now they're on the hook personally. premises, anytime you have property you own and you've got guests or you've got employees or you have customers coming on that premises, you could potentially have liability. And then many folks with kids, especially those in their teenage years or college years who are driving cars, in many states that liability comes back to where those cars are domiciled, which is the parents, and there's liability there. So I think there's a lot of reasons. Now, I'm not someone in any of our books or any of the talks that says you should lose sleep every night until you put in the most drastic asset protection plan you need to. No, but on the other hand, we see this one pillar of 4 pillars of wealth planning at OJM. You want to build that wealth. You want to reduce taxes on that wealth. You want to have a good plan to distribute that wealth. But you should also spend a little bit of time and a little bit of money on protecting that wealth. Because while it's the odds are in your favor, most clients that have set up planning with me over the years have not needed it. Just like disability insurance or term insurance or cash value life insurance, from a death benefit point of view, you could probably get away without it, but you don't want to be that one person that you know that has this liability and didn't do anything that they could have done. So now let's turn to the a little bit of fundamental background on asset protection planning, which is, use this in all the books and talks, which is the sliding scale that we use. I use from -5 to +5. Assets in your own name, generally assets owned jointly, are going to be in that negative position where either half of it, -3, or all of it, -5, are totally exposed. And from a business point of view, the same thing, meaning if you have an asset in your business, let's say it's intellectual property, it's patents. If there's liability and there's a judgment against that business for any reason, employee claim, et cetera, they can get to that patent, that intellectual property. Any asset owned in the business, subject to business creditors. Any asset owned personally or jointly, going to be subject to some degree to individual joint creditors. At the other end of the spectrum are assets that are +5, exempt assets, truly off the table, or if the coast is clear and you've given the asset away truly, okay, where you don't have any rights back and you are giving it away to a trust to that benefits other family members perhaps, then those are off the table. What state and federal exemptions? Well, federal are the same across the country. State really do vary significantly. The one maybe many people have heard of is a homestead exemption. I live in Florida. The Florida exemption is unlimited in value. There's some geographic limitations, but you can have on less than half an acre in an urban environment in Florida a $25 million home, and it's totally protected from creditors. Contrast that to New Jersey that has 0 homestead creditor protection. The states vary widely, and that's why the planning varies by state, especially in states that have community property, as we'll talk about in a second. So we try to get clients to leverage those exempt assets as much as they can. But in between the negative positions and those exempt assets are what lawyers do. They set up certain types of trusts, certain types of other entities like limited liability companies, limited partnerships, etc. And each of these has a varying degree of protections, of costs and benefits, and those somewhat depend on states, but mostly depend on how you draft them and what the structure is. So our goal when we're talking to clients from an asset protection point of view is not to get them to +5 across the board, whether they're business or personally. That's not possible. But it's also not a good idea, and our goal is to move them from a completely negative position. We want to move them, especially the key assets, the most valuable parts of the business or personal net worth, from a negative position to at least a positive position where they're not just exposed, they're not just hoping nothing happens, but they're actually in a good place that even if something does happen, they've got some strong protections, some strong discouragements, and maybe even some of the assets are truly off the table. So given that as the background for asset protection, what are the 3 mistakes we're talking about today? Number one, see this very common, this is really a personal planning mistake, which is I'm married, I have a potential liability. Maybe I'm a specialty surgeon. Maybe I'm a real estate developer. My spouse isn't involved in anything. I don't run a business and the spouse isn't involved in that, and I may have liability from the business. I'm just going to put everything in my spouse's name. And I get that question a lot when I'm speaking at conferences. I see that from clients who come to me. Just saw a client actually this week, and that was their plan. That's been their plan the last couple of years, and we may tweak that. But I had to tell them that, under their state law, it doesn't look, we consulted with another attorney who practices in that state, that it's not that effective, or at least there's a lot of questions around it. And it's certainly not something I would rely on personally. So what are the downsides of spousal titling? Well, in community property states, which are a lot of the Western states, most notably California, where I still remember the bar, community property means any asset acquired by the marriage during the marriage is community property. There are some exceptions, like if you inherit it and you keep it separate, et cetera. But generally, the assets you earn, et cetera, stock in your company, your investment portfolio, et cetera, these things are going to be considered community property generally. And community property is subject to community debt. That means debt or liability of either spouse. So just putting it in one spouse's name doesn't change it from community property to that spouse's personal property unless you do a transmutation agreement. And that's a whole another ball of wax, and that may have a lot of impact on bullet number 3. Even in the non-community states, it's generally not effective. Now, I say generally, okay? Now, we wrote a book, as you can see, for Ohio physicians, and we did that with 4 attorneys in Ohio, all in their own practices. And they didn't agree on a lot of things, as 4 attorneys would not, as you expect. But one of the things they did agree on was you could use this structure to some degree for certain assets in Ohio. So again, different states look at it differently, but it's generally ineffective. And when I say there's even gray area, which there is in many states, why not use something else? If you're a physician, you would not prescribe a medicine that it might work, it might not work. We don't really know. It has these side effects, but why don't you try it? If your physician told you that, you'd probably say, why am I taking that medicine? That's the way I look at it here. If we don't know it's effective and there's serious questions, at best, and maybe ineffective at worst, that's not a good tool, I don't think, in the asset protection tool bag. Now, even in the states where it may be effective for asset protection purposes, meaning for purposes of future unforeseen creditors, lawsuits, things like this, what about marital dissolution? Meaning, yeah, it might protect you against a lawsuit that may or may not happen, and odds are very low that you're going to lose assets. Doesn't mean you don't want to protect against it, but the odds are low, versus more than 50% of marriages end in divorce. So the question I typically ask is, you put all your assets in your spouse's name. Well, what do you think happens when you get divorced? And I'll usually get the answer, well, of course, I put it in the spouse's name. But you and I, we know it's joint, and then when we get divorced, it's 50-50. Well, I say, how do you know that? How do you know it's going to be effective against outside creditors and lawsuits, but totally ineffective and ignored in a marital dissolution lawsuit, right? In a divorce overseen by court. And why would you think you get your cake in one sense, protected against creditors and lawsuits, and get to eat it too in terms of it's also treated completely jointly after you've given it away, supposedly, by putting it in the spouse's name? So I think that it makes it even more risky, even in the states that allow or potentially allow the protection. You want to have, I think, unless you're absolutely sure your marriage will survive, and that's pretty hard to know 10, 20, 30, 40 years in the future, what is the impact going to be? What's its impact? If you're going to rely on this as strategy, you better go to a family law attorney in your state who puts in writing that you're still going to have what you think you're going to have. So again, for all these reasons, okay, bullet number 5, better options exist. It's not something I generally recommend, and normally are steering clients away from that and looking at other options. Okay, mistake number 2. Now, this could apply to both a business or personally, okay, which is, I don't want to do asset protection planning because I think it's expensive. I don't want to pay lawyers a bunch of money and et cetera, et cetera. But normally, and I can't say for every client, but for most clients, asset protection planning is not expensive. And I ask a client this, let's say your net worth is $1 million. Certainly I have clients who have net worths in the tens of millions. And I have some clients who have net worth well under $1 million. But I say, what percentage would you pay to put some protection around that asset? 1%? Is it worth 1% to protect 100 cents on the dollar? Is it worth 1 cent? Is it worth 2? Is it worth half a cent, et cetera? I think that's the order of magnitude you should be thinking about. And for a lot of clients, they may be using exempt assets, okay, where there really aren't any costs, quote unquote. It's part of what they're doing anyway. Meaning, I have my primary residence in Florida. I was going to have a primary residence regardless. Well, how much I put down, how much equity I build up there versus pay debt, because it's totally protected, +5 exempt in Florida. What's my real cost of living in that house? I would have lived in a house anyway, right? So a lot of clients have qualified plans or IRAs, and those are protected. So you can sometimes use some of your exempt assets as a large part of your asset protection planning, where you don't have additional legal, accounting, or state annual costs. Those you typically are applied to the legal tools. This is another reason why I think OJM Group is so well positioned to give clients good asset protection planning analysis and recommendations, because we're looking and we understand exempt assets. We understand benefit plans. In fact, we do those day in, day out for businesses and for individuals um, with our insurance and benefit planning division. Okay, it's not even me; it has the expertise. They have it. So I may say, yes, this is a great tool for asset protection, but they know how to implement and show you the different costs and benefits and design the plans. Same thing. We're very familiar. We have CFPs of how much debt you should have here, and helping you evaluate sort of cash flow and debt here versus equity there. Okay, we're very familiar with certain exempt assets like cash value insurance and cash value annuities that are exempt in about 20 states. So all of these tools we're very well versed in. And I can say, as an attorney, when I practice law at a good firm in New York City or in California, that lawyers, if you go to a lawyer for an asset protection plan, they may not be so familiar with these exempt assets or benefit plans or debt or all of these tools that should be part of your plan. And those are often the ones that don't have a lot of additional cost to them. Okay. And so what I find is that people who go to an attorney for their asset protection diagnosis to map out the plan, they're going to get a lot more legal tools and a lot more expenses than those who come to OJM, where we're able to look at all the different tools. Think back to the sliding scale. Some of those legal tools are really important, but the best tools are typically not legal tools, because not only do they not have those additional costs, but they're actually more protective. So if you're not doing asset protection planning because you think it's going to cost tens of thousands in legal fees, I think you're thinking about it incorrectly. Very few of our clients have more than $8,000 in the one-time fee, and maybe a couple thousand a year to protect a lot of their assets. Okay. Now, obviously, more higher net worth, more complicated businesses could be higher than that, but normally it's a pretty reasonable expense. I very rarely have clients who have walked away from some recommendations because there's high expenses. That also means avoiding too complex or offshore planning. Again, things I normally see when someone goes to an attorney and they come to me and they say, I implemented this $40,000 asset protection plan that had an offshore trust and a Bahamian foundation, and the money moves here and there and this way and that way. Very complex, not the kind of thing I get involved in or recommend. And oftentimes that client, in fact, I'm thinking of one, could have done much better, meaning they could have just protected their assets at a +5 level by using an annuity in their state, which is totally exempt. So is it worth putting the money in an annuity where they can own it, control it, don't have to pay lawyers, don't have to do any additional costs? Obviously, there's cost in the annuity. They got to find the right tool, the right product for them. But that's totally protected, off the table. Everybody knows it. Than some very complicated offshore structure that may protect well, but is expensive and may even bring on some more IRS audit risk. For most clients, the legal tools are what I call the building blocks, which are LLCs, family limited partnerships domestically. And while there's a range of attorneys, and my law firm does this in terms of the cost, but I mean, you should be speaking between, a couple $1,000s and maybe $5,000 to $8,000 for these entities. And if you're doing a couple, you should be able to reduce the cost on obviously the multiple ones. So you get some significant discounting, and a couple $1,000s a year to keep these things in place. You should have annual meetings, you should have compliance, you should do everything right. But again, it shouldn't be breaking the bank, especially if it's protecting hundreds of thousands of dollars or millions of dollars of net worth. And some of those benefits tools have other benefits. I mean, certainly the exempt assets. Most people don't own a home for asset protection planning. They own it because they want a place to live. Most people don't fund a qualified plan or an IRA or a cash value life insurance policy or an annuity just for the asset protection. They're doing it because of the tax-free growth or the tax-free access or the investment downside protection or the allocations or the tax benefit going in with a qualified plan. All of these other benefits for savings. But hey, they also get the asset protection benefit as part of it. So that's why designing a full multidisciplinary, multi-tool plan is really the way to think about your asset protection planning. Finally, mistake number 3 is once you've done some planning, and most clients who come to me, I say most, but I would say at OJM, I look at the asset protection work of clients who've done something already. I probably look at about 30 LLCs and partnerships per year, maybe 40. And so OJM on the consulting side, we've been in place for 10 years. So now I've looked at the work of, let's say, 350, 400 law firms looking at limited liability companies, looking at family limited partnerships, and to some degree trusts that have already been created. And mistake number 3 is assuming that those really are protective. Because just like I could have a will that's totally different from your will, and if we don't have a will at all, then the state intestacy laws are in place. If you don't have the right language in a limited partnership or an LLC specific for asset protection planning, and again, out of the 350, 400 LLCs and limited partnership agreements I've looked at from law firms, less than 10% have everything I'm looking for. And it's not because I'm the smartest guy in the room. It's because not only have I been doing this for 20 years and setting up over 1,000 entities, but I have also now looked at the work of 300, 400 law firms. And every time I see something I like that I haven't seen before, I put it on my checklist. Now I have a pretty substantial checklist of the things I want and I want to see. And it's not because I came up with it. I've learned from everybody else. So I think, unlike most lawyers who use their document, and maybe they go to a CLE conference, maybe they talk to a couple of friends, and they tweak it every year, I've looked at the work of 350 firms because I'm reviewing on the OGM side other people's legal documents to seeing if there's things that could be improved. And because of that, I probably have one of the more comprehensive checklists in the country. And in fact, I did another video on this, on are there weaknesses lurking inside your limited partnership or LLC, because these are the things I see every day. The good news is they're easy to improve. From a limited partnership and LLC point of view, generally, in a family context, you just need the people who are the owners to sign off on an amendment, and that can be done very easily and inexpensively. Okay. So now with irrevocable trust, that's a whole nother ball of wax. Okay. So one, you need the proper language in the agreement. If you want the charging order protections, you better have the language that mirrors it. If you want the ability to allocate differently or distribute differently, you better have that in the agreement. Because if it ever gets challenged and it's not there, you're not going to get that benefit. Okay. The second thing you need is annual compliance on the formalities. I've had clients who have LLCs who've let it become dissolved under their state because they didn't pay the state fee or file the form every year, who haven't filed a tax return in 4 or 5 years, who never had an annual meeting. If you don't have these compliance things in place, or if they never funded it, they have an LLC that's in good standing, but they don't have any assets in it, or they think they have 3 accounts in it, but they only have 1. All of these things need to be done if you want the protections at the end of the day. You got to take the medicine and take it properly if you want it to work. Seems simple, but so many clients lose that. And some of the times my law firm gets engaged to take over an entity that someone else has created because the clients want to have that annual compliance, so we can do that. And then finally, if you have a choice, you should have your limited partnership or your LLC in the best jurisdictions. Not all states are the same. Now, if you're going to have real estate, if I have a client who's in Georgia, where I was earlier this week, and they have a Georgia rental property, they have to use a Georgia LLC for that rental property because they have to file to do business there. And to me, in my view, it doesn't make sense to use an out-of-state entity for that because even if you use an out-of-state entity, you'd have to file to do business, which means you're subject to the LLC to the laws of that state. So with real estate or with a business that really has a place of business, a situs, as they say, you really have to use that state's law. However, if I have a client who has a portfolio, right, and I use my example, I live in Florida. OJM Group and the investment team manages my money. They're based in Ohio. But the assets are held at a third-party custodian, Charles Schwab, the largest custodian in the world, who's obviously a multi-state company that has maybe a main office where one place and jurisdiction of domicile in another state, and they operate business in all 50 states. So when I check my investment portfolio online today, where are those assets? Well, I think you certainly make an argument they're not in Florida. They may be wherever Charles Schwab does business. So the point is that we have flexibility on the investment portfolio to use a state that has the best asset protection law. So if I see a client who has an LLC, they may have great language, they may be compliant, but it's not in the best state, we're going to think about redomiciling to a state that has the best protections in their statute and get that extra level of protection. So that's mistake number 3, is even those people who have documents in place, who have entities in place, assuming they are protected, if they haven't been reviewed, they may be suboptimal. And also, by the way, rules change, laws change, statutes change, and just like your will, it's probably a good thing to review, even if you feel confident all these things are in place. So, asset protection, one piece of how OJM works with clients. We're a pretty unique wealth management firm. If you haven't heard of us, or this is the first webinar that you have heard from us, certainly asset protection, my area of specialty, but we work with a lot of clients on tax reduction, businesses on corporate structure, benefit plans to help save taxes, build retirement wealth, and all the different types, retirement modeling and financial modeling, and building a plan for a business, for a person or family in terms of where they're trying to get to and how they're going to get there. And are they behind or ahead or on track? Insurances, everything from life insurance, disability insurance, long-term care insurance, looking at group policies for business, also in conjunction with some of our partner firms, property and casualty insurance, which is a key part of asset protection planning, like umbrella coverage, business coverages, personal, homeowners, etc. And obviously our wealth management, our investment part of our wealth management firm, where we manage about $350 million for clients across the country on a fee basis, on a outside custodian basis, really the way I want my money managed and other of my family members. No conflicts in terms of us trying to sell products. We get paid a fee. We're not trying to push any proprietary products. So we're in line with our clients' objectives, which is to grow their wealth. So that's OJM Group. As I mentioned, unique, I think. We have the consulting side where most clients start with us. And part of that consulting could be asset protection. We have some clients, they say, listen, I just want to hire you guys to look at an asset protection plan for me. And I'm the one you're working with. I do that analysis and move that forward with you. Some clients want all the different areas: asset protection, tax, investments, financial modeling, insurances, etc. It's up to the client. We have over 1,000 clients in 48 states. We work with businesses. We work with clients personally. In terms of next steps, certainly we're always happy to chat with you. If you're interested in talking about asset protection, contact me. There's my email, Mandell@OJM Group. Happy to set up a consult. We always talk with clients, prospective clients, for free, no obligation, initial consult. Let's discuss how we can help you, what your interests are, what's on your mind, questions we can answer, see if there might be a fit. If you want any of our books, including you want to sign up for the new book that's coming out within the next month or so, the investment book, shoot me an email, get on our website, go to ojmbookstore.com, go to ojmgroup.com, look for our books and articles, and you'll see all our material. So hopefully this was helpful for you. Hopefully you will avoid those 3 mistakes or try to remedy them. And certainly I'm available and happy to help you get on your way to putting a good asset protection plan in place for your business, for your personal, for your family now, and one that is maintained properly in the future. Look for our emails. If you're signed up for this, obviously you're getting our emails, and obviously we do a monthly webinar. So this is for this month, but we have lots of interesting topics and good speakers coming forward. So look for those in the future. Thank you very much.